So you guys have met me. My name is Neda, and I'm the Prisoner and Family Support Coordinator. And I think, yeah, everyone in here I've pretty much met so far, I think. But yeah, so I'm really excited for today's workshop, and I'm going to introduce you guys Amith. And basically, I also just want to start off by saying the intention of the workshop is really for the impacted family members to be able to, use the space to, learn how to help their loved ones. And sorry, let me read this. Amith Gupta is a staff attorney at CCF. Prior to joining the coalition, he was a legal fellow at Project South, where he focused on issues pertaining to surveillance of Middle Eastern, South Asia immigrant and Muslim communities. Amith earned his Juris Doctor at New York University School of Law, where he was an Institute for International Law and Justice Scholar. Prior to joining the legal and advocacy team at Project South, he worked as an appellate level public defender in Manhattan. Amith's studies and activism focus on U.S. foreign policy, war, borders, and the Middle East. Prior to law school, Amith earned his BA at Bard College in Political Studies and Middle Eastern Studies. He is originally from the Bay Area of California, but has lived in New York, Spain, Egypt, and Lebanon. Also, not mentioned here, Amith wrote the very successful compassionate release motion for Sami Hassoun, which resulted in his release, alhamdulillah. And I'm sure also many of you have met him at the previous family conference that was in person in DC. Yeah, so take it away, Amith.
Well, thanks so much for that introduction. Okay, so everybody, it's good to see folks. To be honest, I can't really see anyone, but it's good to know you're there. So as Neda mentioned, this is a workshop primarily for impacted families. So what we wanted to do was basically talk about the law of litigating and challenging prisoner abuse in the Bureau of Prisons. So what it's important to note is that this is there are two of me right now. So I just want to make sure you guys are looking at the right one. Okay. Okay. There are. Yeah, so basically the gist of why this is important is that on the one hand, we want to make sure that all the CCF families have the ability to challenge abuses against their own loved ones. But there's also the question of righting wrongs throughout the system. And for a long time, courts were very actively focused on challenging and being part of the process of challenging prisoner abuse in the BOP system. So for a long time, courts were very active in basically policing the way the insides of prisons and jails worked. And then Congress got involved and kind of screwed it up and made it very difficult. So we're going to talk about that too. But basically, I want to make it clear what this presentation is about. So this presentation is about challenging and litigating against the federal government about misconduct in federal prisons. So a lot of the stuff that's in this presentation doesn't apply to abuse in state prisons. And the other thing that we have to consider before we go forward is that the law on every one of these issues varies widely across the country. I think there's some background noise. If the host could like mute the okay, perfect. So the law of the country varies widely, and it depends really where in the country you're imprisoned. So even if the place that a person is imprisoned is different from the place that they were convicted, the law governing prison abuse is the law of that place. And what that means is that there are a number of different issues that are affected by the law of that state. Even if you're in a federal prison, depending on what kinds of claims you bring, it can be affected by the law of the state you're in. And there are basically the federal judiciary is divided into 11 circuits, which are geographically separated. So which circuit your prison is in can also be very important. Okay, so before we actually talk about what the law says you can sue the prison over, we have to talk about one of basically the worst part of the congressional reform that they passed in 1995 called the Prison Litigation Reform Act, or the PLRA. So the PLRA was basically this effort by Republicans to say, well, prisoners keep making up kind of bogus lawsuits, and so therefore we need to make it harder for them to sue. And it was largely an imaginary problem. It wasn't completely true that prisoners were more likely to file frivolous suits. The reason it seemed that way is because when you're in prison, almost everything that a person would normally sue over suddenly involves the prison. Like you don't have like disputes between neighbors anymore. You have disputes between you and the prison. So I mean, almost every legal problem that comes up in a prison will involve the prison, which is why there happen to be a lot of suits. But basically, the Republicans passed this law that made it very difficult for lawsuits to be brought. And one of the biggest issues was how you exhaust administrative remedies before you can go to the court. And what that basically means is you have to go through the prison and the Bureau of Prisons process before you can actually take your case to court. So as far as how that works and what that looks like, one of the most important things to keep in mind is to get a copy of the administrative rules and regulations of the individual prison that your loved one is held at, and make sure you have that with you. Whenever something happens, whenever there's something that becomes grounds to sue or any kind of abuse that you want to challenge, it's important not to delay, because one of the ways that the PLRA has undermined the ability of people who are incarcerated to challenge abuse against them is to make it is to create deadlines that go very rapidly. So we're just going to go through. I'm going to go through very quickly what that process looks like. So first of all, once the abuse, whatever it is, whatever the incident is, or whatever the concern is, once it happens, the clock starts ticking. So, and every one of these prisons, you have to first pursue the informal resolution process. This is going to vary by prison, and it depends on what the warden of that prison has set up to solve any issues. And even though it says it's informal, it's important that you make a record of it. You have 20 days to pursue the informal mechanism to address whatever the grievance is. That's important because the next stage is the formal resolution. And what's important to note is the deadline for this is also 20 days from from the time of the grievance. So you have 20 days both to file the informal resolution and the formal resolution. So what I would suggest is file the informal resolution as quickly as possible, and then at the same time, resolution. Don't assume whatever it is will be resolved favorably. Again, the primary reason that you want to make sure to go through all these processes is not because you think that the Bureau of Prisons is actually going to address any of your concerns. The real reason is that you want to make sure that this is taken care of so that you can file something in court. So the initial filing that you have to file within 20 days, again, this is in addition to the informal resolution, the first formal filing, which is also due in 20 days, that's called the BP9. And so as much as there are exceptions to the 20-day limit, if your loved one is actually like physically prevented from accessing the form or writing the form or submitting the form or whatever, then they sometimes waive the requirement, but it's important not to take the risk. So basically, you hand the BP9 form. You take it. It should be available with the counselor. It says what's an informal. So the informal resolution is basically the thing you're required to do before you file the BP9, before you file the first formal complaint. And the reason it gets confusing is because the informal process and the formal process, both of them, you have to complete them both within 20 days of the bad thing that happened, basically. But the first step in the formal process is you file the BP9. So the BP9, you get this form from the counselor, from your counselor. It'll basically ask you, what's the problem, and sometimes it even asks you, did you already go through the informal process that we have set up, and you're required to say that you did. You should make multiple you should make multiple copies of this form because you'll need copies of them later, including for litigation. And it's important to remember that you fill out one of these forms for each complaint. You can't just put every complaint on one form. So every individual instance in which something bad happened, you have to file a different BP9 form. When you fill it out, you gotta mention that you filed an informal complaint. You should include a line that mentions the deadline by which you expect a response. So that deadline, they have legally 20 days to respond to your BP9. So you should include a line that says, I expect a response to this within, and then put whatever is 20 days plus change, usually 22 or 23 days, because you want to give them time to actually for it to go through the mail. And say, I want a response by that time. You should explain what the grievance is with as many details as possible. So include names, include exactly what happened, see if you can get the time in there, witnesses, whatever you can find, whatever details you can get, be as detailed as possible. You are given the form itself plus one extra page. So you should ask for a response within 23 days. Once they are basically 20 days plus a few days. If you get a response that doesn't address your concerns or address all of your needs, or if you don't receive a response in the appropriate time, that's when you move on to the BP10. So this is a form that has to arrive at the regional office within 20 days of the warden signing your previous, signing the response to your previous request. So again, it's not 20 days of you receiving a response from the BP9. It's 20 days from the warden receiving it. So you may not know when that is, but the important thing is to act as quickly as possible. So once 20 days have been up, 20 days plus change, whatever date you put on the BP9, once that's up, be ready. You should be ready to file a BP10. This is sent to the regional office. So depending on where in the country your prison is, there's a different regional office for different parts of the country. Those should be included. Your counselor should have the address, but I can also send these out. You should, again, keep as many copies as possible. It should also include a copy of the BP9. So one of the copies you made of the previous complaint should be included in the BP10. And then this is sent to the regional office. Now, if you, now within 35 days of you filing that first appeal, you should file an appeal with the next level up, which is a BP 11, I believe. When you file this appeal, you're filing it with the general counsel of the Bureau of Prisons. So that you should file that. If you get another response that you don't like, or if you don't get any response at all, you should file this. Include copies of the previous filings, and then if you don't get a response to that within, I believe it's within another. I believe it's 30 days. If you get all the way to the top and you don't get a proper response to that, that's when you have the right to go to court. So again, it can be kind of confusing because the deadlines don't match. Sometimes it's the deadline of when you receive something. Sometimes it's the deadline of when you send something. So they make it confusing, but it's important to go through this process. And I can also I should also be clear. The contents of this presentation, we're gonna put them in written form, and I will make sure it's sent out to everyone. Okay, so that's what's basically the required the exhaustion requirements of the PLRA. There's other stuff in there that makes things hard. You have to even if you're broke, you have to pay a $150 filing fee, and if you don't have $150, they take it out of your prison work account. So there's other issues like that, but in terms of getting into court, that's the prerequisite. Now, when it comes to actually going to court, we have to not every complaint is actionable, and it's important to remember, like sometimes sometimes I get calls from people and they say, oh, I have this terrible violation of my rights. And I say, okay, what is it? And they say, well, the food here sucks. I'm surrounded by terrible people. The guards are mean to me and I don't like it here. And I say, yeah, that's prison. I mean, that's not a grounds to sue prison. It's supposed to suck. I mean, it's supposed to be an awful experience, which is terrible, but unfortunately the courts don't allow us to sue for everything. But sometimes there can be ambiguity about what kinds of things you can actually sue about. So it's important not to sacrifice your own rights before you've even made the effort. So in this section of the presentation, I'm going to try to go over some of the kinds of things that you can sue over in a federal prison. So there's basically two categories of the kinds of claims you can make about misconduct and abuse in a federal prison. So the first is basically what are called Bivens claims, or basically constitutional claims. These are claims that a federal officer of the law individually did something that violates your constitutional rights. So there's not a full list of what counts. And in recent years, the Supreme Court has been unwilling to kind of extend the rule that you can file a constitutional claim under this rule called Bivens. But in general, certain types of claims that are common in the prison setting, you can still file them in a federal court. So I'm just going to go over some of them. It's important to remember this isn't an exhaustive list. These are just some of the kinds of things that are common in prison, but it's not exhaustive. So the first is the unlawful use of force. So the unlawful use of force is governed by the Eighth Amendment. And it's important to note that in prison, the standard for what counts as an unlawful use of force is much higher than normal. It's much higher than than it is for inmates who are in pretrial detention. It's much higher than for people who are subjected to police violence outside of prison. Inside prison, the standard is that even things like unreasonable force or excessive force, that's not enough to state a claim to sue somebody. It has to be what they call malicious or sadistic. So a lot of the times, what counts as an unlawful use of force in the prison context has a lot to do with what the officer is thinking and why he's doing it. So for example, a completely unprovoked beating where you're minding your own business and he just starts hitting you for no reason, just because he's a crazy person. That is an example of something that probably would count. But examples of things that don't count is, take, for example, if there's a prison riot or some kind of situation where the prison authorities have to maintain, reestablish control. Even if they use force that's excessive and that seems like it wasn't justified in the situation, if it wasn't carried out with the aim of sadism or malice, if the court doesn't believe that the use of force was essentially intended as a kind of excessive use of force, then you may not be able to sue over it. It's worth noting a serious physical injury is not necessarily required. So even if you've been subjected to excessive force inside prison, even if the reason even if there's no even if there's a serious physical injury or there isn't a serious physical injury, you can still prevail. However, a serious physical injury might help establish that there was an excessive use of force. It's also worth noting that if liability is found, if you can successfully argue that a prison guard or somebody else used an excessive amount of force, then even injuries that are unique to the prisoner can be grounds for damages. So, for example, if a prisoner has, kind of a weak immune system, and a guard decides that he's going to, for no reason at all, spray the prisoner with mace or spray the prisoner with pepper spray, just to be, sadistic. Even if a normal person would not have serious problems, if somebody with an immune system problem or respiratory problems, if they suffer greater injury as a result of that, you can get greater damages. It doesn't matter that the injury wouldn't have been as significant if it had been done to another person. So those are things to remember about injury. Another common grounds for prison litigation is what's called deliberate indifference. So this is where prison guards kind of don't take it seriously and don't make an effort to protect inmates from threats that they know are there. It's important to understand the distinction. It's not threats that they should have known are there. It's threats that they do know are there. So examples of this would be putting somebody in the same prison cell as someone from an opposing gang. So if the guards know that two people are from opposing gangs and they purposely put them in the same prison cell and one person gets stabbed by the other person, and they knew that that was likely to happen, they can be held liable for that. Likewise, if they hold somebody, if they put a person in prison with another person that they know has mental problems, that they know has, for example, down here in Georgia in a state prison case, there was a man who was arrested who had just committed a violent hate crime against a completely innocent person. And then they put him in the same prison cell as someone from the ethnic group that he doesn't like because he's a racist. And then the guy got stabbed. So they were able to sue and said, you had to have known that this guy was a violent racist. So there's really no way you couldn't have known that, and you deliberately were indifferent to it. Another example of deliberate indifference claims is when they're deliberately indifferent to a health problem or a sanitary problem. For example, if they put you in a cell where they know that the conditions are gross and awful, or there's like blood or bodily fluids and things like that, and they know that it's unsafe and that it results in some kind of suffering, you might be able to sue over those kinds of things. Another very important category of deliberate indifference claims is deliberate indifference to a serious medical need. So when you, as a person who's in prison, have a serious medical problem and they willfully ignore it or just don't make an effort, you can sue them. But it's important to note that it's not like medical malpractice. It's not enough that they just didn't do enough, or that they didn't do it properly, or they made a mistake. It has to rise to the level of them willfully disregarding the potential harm. So examples of that are, somebody being violently beaten and having their bones broken, and the nurse sends them back to the cell with Tylenol or something like that, where they're just purposely disregarding it. Or if they know that from the doctor that you have a serious medical problem and that you've been prescribed this medication, and they say, we don't really want to give you your medication, we don't care. You'll suck it up. You'll be fine. If they do something like that, then you usually have grounds to sue. It's worth noting that even where they provide some medical care, it can still count as ignoring a serious medical need. So it really depends on the situation. Likewise, if there's a policy that the prison has to not address certain kinds of serious medical needs, you may be able to sue the entire agency. Okay, so those are honestly the most common, which is stuff involving the use of force or deliberately being indifferent to those kinds of threats. But there are other sorts of claims that come up in the prison context as well. So one that I want to talk about especially here is stuff relating to religious discrimination and religious freedom. So I want to distinguish between what these two things are. So religious freedom claims would be under the First Amendment, and these are claims where a person is just deprived of the ability to practice their religion. Now, oftentimes this happens in a discriminatory fashion, but it doesn't have to. So, for example, if the prison prevents everyone of every religion from, reading their holy book, whether it's the Quran or the Bible or whatever, if the prison prevents anyone of any religion from reading or practicing or worship, those would be religious freedom issues. You're entitled to practice your religion, even if other people who are also who are from another religion are also being deprived of their right to practice their religion. Everyone as an individual has the right to practice. On the other hand, religious discrimination claims are saying basically, here's a particular group of people who's from a particular religion, and we're going to treat them differently because they're from a different religion. So when it comes to religious freedom claims, normally the reality is that prisoners normally don't have strong First Amendment claims, because it's kind of assumed by the courts that a lot of the times when the prison regulates things like speech and media and things like political associations, things like joining a union or forming an organization inside the prison, that if the prison is doing that, they kind of defer and assume, well, they probably have a good reason for doing that. And so we don't want to say that in that case, there's a First Amendment claim. The exception to that is religious expression. The Congress has passed a law called the Religious Freedom Restoration Act, which basically says that if they're going to regulate conduct that in some way affects a person's religious practices, and it really is that person's religious practices, then they have to, basically the gist of it is they have to have a really good reason. So in some cases, that lawyers have actually been quite successful in challenging some of these practices. So when it comes to, for example, not providing meals that meet certain dietary restrictions, like not providing halal foods to Muslim prisoners, or things like arbitrarily telling prisoners you're not allowed to fast for Ramadan, you have to eat now. We're not going to accommodate, having to eat at sunup or at sundown. Things like the right to have worship services, even if they're at a time that isn't something that the prison is used to. So, I mean, most of these prisons, the dominant community is Christian, so they schedule all the worship stuff on Sunday. If you can argue, my day of worship is on Saturday or Friday, some other day, they in some cases you're usually able to win those cases because they don't really have a compelling need to say, no, the only day you're supposed to worship is Sunday. So as a result of that, those kinds of claims are often successful. With religious discrimination claims, what you're really arguing isn't that they're necessarily preventing you from practicing religion. What you're arguing is you're being treated differently. And sometimes they make it obvious. Sometimes they'll just say, yeah, we don't like Muslims, so we're going to discriminate. And those cases are easy to win. The problem is oftentimes they don't admit that that's what they're doing. And so that can be tricky. But you can allege religious discrimination and other types of discrimination, for example, by design. So hypothetically, for example, let's say the prison says, oh, we have two different eating halls, two different mess halls. There's one mess hall for people who eat pork, and there's another mess hall for people who don't eat pork. And the mess hall where people eat pork is really nice, and it has, cookies and ice cream, and it's set up really well, and it's open all day, and you can go in whenever you want. But the mess hall where non-pork items are served, that one's covered in trash all the time, and it's locked half of the time, and you can't even eat there. And so those are the kinds of claims where, the government's going to have to explain, why do you have two different mess halls based on who eats pork? Those are the kinds of claims where you might be able to succeed in challenging the issue based on religious discrimination. Now, as I mentioned earlier, free speech claims in general don't independently of religious freedom, don't kind of First Amendment claims, they don't generally succeed, but every now and then they do. So, for example, you can sue under the First Amendment if the government tries to force you to become a prison snitch. Your right to not turn over information to the government, that's protected under the First Amendment. Likewise, things like retaliation for protected speech, if you, for example, choose not to be a prison snitch, and they come after you and say, I'm going to take away your right to do this, I'm going to take away your privilege to do that, you can also sue over that. Any kind of what's called an adverse action that's premised on a prisoner invoking their, practicing their First Amendment rights is going to be grounds for lawsuits. Another area which is somewhat common is procedural due process claims. So these are claims that basically, if the government is depriving you of something, even when you're inside prison, there has to be some kind of process. Now, the reality is, of course, if you're in prison, you're already being deprived of a lot of stuff. So for a lot of things, you won't be able to state a claim. But for things like, for example, putting somebody in solitary confinement, if they didn't give any process for that, and if the result of putting you in there is to take away your access to things that are like a normal part of prison life, you might be able to sue over those things. if you didn't get the proper, if you didn't get the opportunity to challenge the reasons for being placed in there and so on. Now, privacy issues. This is another area where, again, because of the nature of being in prison, it's very difficult to state successful claims. However, one area where there's been some successful challenges include things like unreasonably searching visitors. So, for example, if you have visitors and there's really no reason to think that a specific visitor has contraband, but they subject that person to extra searching, or they subject that person to some kind of unreasonable search simply because they're your visitor, or frankly for any any reason that's not based on reasonable suspicion or probable cause, that might be grounds. The other area where this is an area that prisoners have had some success in is with kind of particularly intrusive searches like strip searches or body cavity searches. When those searches are carried out arbitrarily or in a way that doesn't really have any apparent purpose, or another instance in which that's common is when they are related to gender. So, for example, if you have people of the opposite gender conducting body cavity searches, oftentimes those are upheld as unlawful searches. Likewise, when they search, but they do searches based on gender, like, for example, when they search men but they don't search women, or vice versa, that's oftentimes a sign that the search isn't for whatever reason they're giving, and that it's being carried out unlawfully, but not necessarily. Okay, so that kind of goes over most of the constitutional claims you can bring. The second category of claims you can bring are claims that are not against the individual officers or the individual staff people, but they're actually claims that you're bringing against the United States government as a government. So normally you cannot sue the United States government. This is a rule that goes back centuries, that basically says, if you're in court, you can't sue the government whose courts you're in. And this is a rule called sovereign immunity. But basically, most people who believe in democracy or basic rights think that that's kind of dumb. So they passed a law in the 40s called the Federal Tort Claims Act, which basically says, okay, the United States government still maintains that you can't generally sue the United States government, but we will consent to being sued in certain situations. And so basically, they waived sovereign immunity for these certain kinds of claims. These claims are called common law torts. Basically, what that means is they're things that we consider illegal because at some point the court system, going all the way back to like England in the 1300s, decided that certain things are just illegal conduct, like assault and battery and things like that. And so basically, when it comes to these kinds of claims, you can sue the United States government as a whole based on the actions of individual government employees who, when they were acting in the scope of their employment, did something that caused harm. So one category of torts is called basically negligent torts. It's stuff where the government official's negligent action or lack of action caused harm. So one example of that is where they provided the wrong medications or something like that, or where they didn't properly apply the medications on time, and as a result, somebody suffered. You can also, at least for prisons, this is not necessarily true for other suits against the government under the Federal Tort Claims Act, but you can sue the prisons over intentional torts as well. So for some bizarre reason, if you're outside of prison and a government employee intentionally harms you, for some reason you can't use this statute. But in the law enforcement context, especially including in prisons, you can. And so in those cases, you can sue for things like assault, battery, false imprisonment or false arrest, as well as abusive process or malicious prosecution. So there's a number of different suits that you can bring under this act. Sometimes these claims, basically the gist of the thing you're complaining about, will will also be covered by the Bivens claim, the constitutional claims. So these are different ways to kind of get your claim into the court. It's important to note with the Federal Tort Claims Act claims, you have to file over conduct that happened within the scope of the person's employment. Sometimes that can get tricky because in general, you're not supposed to be breaking the law during your employment. So whether or not you did something during your employment, or whether or not the person you're suing did something during the scope of their employment, that can be a tricky issue. It's usually not that ambiguous though when it's like a prison guard. The other issue though is it has to be over conduct that's non-discretionary. What that means is it can't be something where the prison guard was basically told you have to figure out what to do on your own and you have to make a choice. On the other hand, when the conduct was governed by a set of procedures or laws, or they have some kind of set of rules that he was supposed to be following, or that he should have followed, and there was no real discretion, then you can proceed to court. So again, that's kind of the wrap up of the substantive parts. Again, all of these things involve complications that vary geographically across the country. So it's important that if you suspect anything like this happening, that you should reach out to us as soon as possible. As far as what you can get out of these lawsuits, so one is money. So those are damages. Now, here's another area where the Prison Litigation Reform Act kind of screwed over prisoners, is that damages are limited to cases, I should say compensatory damages. That's damages where you're getting paid because you want to be made whole by whatever happened to you. So you want to say, okay, I suffered this injury and this injury is worth, I don't know, $100,000. And it's sometimes it can be kind of vague how you calculate that, but you can, for example, claim, oh, as a result of this injury, I can't work anymore. And as a result of me not being able to work anymore, I lost $100,000 that I would have made from going to work. Or, I had to pay medical bills for this injury, and the medical bills cost $100,000. So it's compensating you for the injury. Those kinds of damages are limited to cases where there is a physical injury. Physical injury includes things like sexual violence as well. However, even in cases where that doesn't happen, you can sometimes get what's called punitive damages. Punitive damages, the court saying, we really want to get the agency that you're suing not to do this crazy stuff that they're doing. So we're going to punish them by rewarding you punitive damage. So you can still sometimes get punitive damages. Likewise, this rule against a rule saying there has to be a physical injury, some courts don't apply this to civil rights claims related to discrimination and things like that. So some courts have interpreted that to only apply to claims involving physical injury or involving battery and things like that. The other kind of thing you can get, which is also important, is injunctive relief, which basically means you can get the court to order them to stop doing something or to start doing something, depending on what it is. There are a number of obstacles in this field that unfortunately, there are a number of obstacles in this field that don't exist in other areas of civil rights law. So one that we already talked about is the exhaustion requirement, and all the procedures and all the easy to miss deadlines that make it impossible to get into court. Another important one is limits on fee shifting. So what Congress did a while back was to say that if you succeed in a civil rights claim, the other guy, usually the government, has to pay your legal bills. And what that meant was if you had a claim that was likely to succeed, really, really high profile, well-paid, fancy attorneys who charge, $600 an hour, you would be able to get them to represent you because you wouldn't have to pay that bill. The government would pay that bill. And as a result, really successful, experienced, high-profile attorneys would be attracted to civil rights cases because there's a strong incentive for them to show up. Unfortunately, in this case, in the prison litigation context, the PLRA caps the attorney's fees at 150% of whatever the judgment is, which might not sound bad at first, but some of these cases, especially when there aren't any compensatory damages, it can be like, even if you get any damages at all, it could be like $1,000. And so, a high profile attorney who works at some fancy firm who's used to getting paid, $600 an hour, they're not going to want to take a case that's where the amount that they can make and the amount that they make the government pay is basically $1,500. It's capped at 150% of whatever the judgment is. Whereas under normal circumstances, even if the judgment was like $1,000, if the attorney says, well, I put in 1,000 hours of work and I charge $600 an hour, so the government has to pay me $600,000, that's how it works normally. In addition, the other big obstacle is something called qualified immunity. So sovereign immunity is the thing that protects the government in Foreign Tort Claims Act suits, FTCA suits. In suits under the Bivens thing, where you're making the constitutional claim, individual officers have this protection, which says basically an individual officer can't be held liable for damages unless he would have been on notice that his conduct was unconstitutional or illegal. And so oftentimes the courts interpret that to be very narrow, like the exact thing that the guy did wrong has to have previously been ruled to have been wrong by the courts. And it also often interprets that to mean not just any court has ruled that this is wrong. It has to be the Supreme Court or a circuit court or the state Supreme Court of whatever state you're in. And unless that's the case, you can't get damages from the misconduct of that individual officer. That's important because, especially given the limits on FTCA suits, sometimes the only grounds to sue on is the constitutional claim. And oftentimes suing an individual federal officer is an important way to win damages because they're insured by the federal government. So individual officers usually aren't the ones that pay the cost of judgments. Usually the government insures them so that the government ends up paying, but they don't have to pay if there's qualified immunity. So that's another reason why, and that's another way that the courts have kind of restricted not just prison misconduct suits, but police misconduct suits more generally. Okay, so it looks like we have about 8 minutes left. Before I end the formal part of the presentation, I do just want to make sure everyone has my email. So if anything happens and there's a concern and you want advice, or you want me to talk to your loved one, or you want me to find someone else to talk to your loved one, you should just email me. My email is amith at civilfreedoms.org. That's AMITH at civilfreedoms.org. Yeah, that's it. I want to open it up for questions. If there are questions that I can't give a complete answer to now, I will write them down and try to get back to you. So yeah.
Hey, Amith. I have a question going back to the very beginning, and I kind of asked this in the comment section, but I just needed further clarification. So you said before the BP9 that they start, which is the formal complaint process, they need to and should also file within 20 days the informal complaint. So if I was talking to my brother or to another prisoner, what does that look like for them? Is that like a slip that they ask for? Is that something that they file with their counselor? I mean, I'm sure that is in their rules and regulations book, but for my knowledge, what does that look like for them?
So it varies between prisons. It's whatever the warden has set up as the informal process. So you have to figure it out for each prison. But it's something to figure out basically on day one. You shouldn't wait until something bad happens. It's something to figure out in advance. It should be. It may even be available on the prison's website. Yeah, you should know what that is in advance, because the 20-day limit applies both to that and the formal thing. So you have 20 days from whatever happened to do both the informal complaint as well as the initial part of the formal complaint.
Now what we've run into is they won't give Alex a grievance form.
Yeah, that's a great question. So one of the ways that you can get around the PLRA exhaustion requirement is if they're purposely making it impossible for you to file complaints. So if that's happening, you can go directly to court. There are multiple ways to argue that they've prevented you from filing the complaint. One is by saying that the officer is just not even giving me the form. It can also be that if the prison has instituted procedures that are basically just on paper and in practice nobody actually follows any of it, or if they're purposely misrepresenting the rules to the prisoners, those can all be grounds to tell the court, hey, you should just waive all of this PLRA stuff because they're not even following it. And you can actually be successful on making those allegations. Of course, it would be ideal to not have to run into those problems. So if you can get it, if you can get the form, you should try. But if they're just not giving the form, then I would proceed past it and say, basically, look, I did my best to exhaust the requirements, but I couldn't. One way that to strengthen that claim is to try to keep a log of every time the form was requested, write down every day and every time it was asked, who the prison guard that was asked was, try to write down as much information and then save it for the attorney. So that's one way around it. The other issue is if you're concerned about retaliation, that you're worried about if I file the form with the prison guard who's harming me, that he might cause even more harm, you can also try to file the initial complaint with the regional office. So the person that you normally send the appeal to, you can send the initial complaint, the initial form to that office instead, so that it's not sent to someone in the individual prison. So yeah.
Now I know you've spoken to Alex before. Now he's run across this like almost every time he's tried to file a grievance, going way back. Now, but what we've done is we've submitted things on his behalf to get it on record with, regional and whoever. So in saying that, is there a time where it's too late to get into court, because he's been subjected to almost everything that you've brought up so far? Like,
so it depending on the courts have different rules about the statute of limitations. Most of the stuff I've talked about, the general rule is you have 2 years to file a lawsuit. They might be willing to waive it if you are trying to exhaust the administrative remedies and just not being able to. So that's an area to talk to an attorney about. Yeah.
Okay. Thank you.
Yeah.
I have a kind of specific question. I don't know, it's a little bit off track. If I may ask it, and if it's something you'd like to leave to a different time, then let me know. I don't really work very much with Bureau of Prisons. I'm not an attorney, but I do advocacy work for Muslim inmates in Care, Florida. This has been really helpful. I appreciate it. Basically, the question is a lot of times, and it made me think of it when you're referring to the grievance process and requesting a grievance and then not being able to submit that grievance because they're not giving the documentation. Another thing that is along the same lines that happens sometimes is when, for example, a Muslim brother is forced to shave his beard and he claims that he's compliant with DOC policy. So it's within half an inch as it claims now, and it's not sculpted. And then it's one word against the other, but then against the admin. So they'll say it was sculpted, or they'll say it was too long, and he'll challenge it and say, no, it wasn't, or he'll say, take a picture of it, or he'll try to ask them for some way to, something that he can do to visually accompany his grievance to show that he is being truthful and honest, but they won't accommodate. And so again, when it's the incarcerated brother's word against the administration, it's it's almost a lost cause. Do you have any input as to what they could do to prove their position?
So is the concern about him being asked to shave the beard at all, or is it just that they're manipulatively saying it's too long or it's too short, and even though he's trying to comply?
It's that they're
it.
violating his religious right, his belief that he, as a Muslim, needs to grow a beard. So they're violating that and forcefully shaving his beard off. And he claims that he's in compliance, and their excuse is that he's not in compliance.
Well, their excuse for what?
Shaving his beard off.
Okay. So one of the areas where the religious religious freedom claims haven't been as successful is stuff related to hair for some reason, because courts are willing to defer to the prison management that not growing hair a certain length or not having hair that covers your face is important for identifying the prisoner or something like that. It's usually complete nonsense, but those are areas where those kinds of claims haven't always succeeded. If he's claiming, look, I'm trying to comply, I'm following the rules, and they're retaliating against me, even though I'm complying, then it might be a different story. Likewise, if they're only subjecting him to these requirements, or they're subjecting him to these requirements differently from other inmates, then he might be able to at least make the claim. In terms of how to prove that it's happening, that's a harder one. I'd have to think about that. I don't know. I don't think you could take a picture or anything like that, but you might be able to get witnesses or have somebody in the command, during the actual litigation, actually try to force the prison guards to explain their position or something like that. But I mean, the fact questions are sometimes difficult in a lot of these cases. Even other cases, you have to think about how you're going to prove the actual issues. So that's if it's something that gets to litigation, which depends on the nature of the claim, then that would be a fact question, and it would basically be conducted through discovery. But it would be difficult. So,
Yeah, thanks for that. I hadn't thought about having a particular brother, and this is probably the largest number of grievances we receive is about the beard situation. So it's certainly trying to be handled by Care Florida, but I hadn't thought about the witnesses. One particular brother mentioned that he challenged the officers and said, look, we're right next to bookings and there's a camera there, take a picture, and they refused, which, I don't suspect he was expecting them to agree. But even his claim speaks to to his confidence in him being in the right. So in any case, yeah, I just wanted to ask about that. I appreciate it.
Well, one other area is that in a lot of those cases, you can try pursuing it through the political means. I mean, sometimes for these kinds of smaller concessions, if there's enough pressure on the Bureau of Prisons, they may just concede, and it's something that advocacy groups can do outside of the prison context and outside of litigation. So yeah.
Yeah. Thanks.
Sure.
James Yee had an interesting comment that he wrote in the comments where he said, at Gitmo, the command tried to make an argument that the forced shaving and beard was done for health and hygiene reasons. Yeah, and then Kathy references a Supreme Court case where they kind of, sorry, I'm reading it right now. But yeah, good comments. Does anyone have any more questions or?
So Gitmo, it's worth noting, Gitmo is a little different because it's a military base, and almost you can't really bring any constitutional claims against in those situations. I mean, even just being able to challenge your detention there was a 2 or 3 year process after the war, the fake war on terrorism began. So,
I think the biggest thing that a lot of our loved ones see, and that Alex is dealing with right now, is being moved to solitary confinement and we can never get a reason why they were being moved there, why they're being kept there, and it just feels like we can never challenge anything because they don't give us any info. It seems like this is a reoccurring thing that happens. And
Yeah.
has anyone ever had real success in being able to get answers so that you can challenge the reasons why you're being put there or kept there?
Yeah, I think there's a lawsuit right now being filed by CCR over the use of like the secure housing units and other types of like solitary confinement. Based on the case law, you should be able to sue that you were denied at least some process. Like they can't completely deprive you of everything without some justification, but the justification is probably not going to be something that I mean, it involves the internal prison processes for investigation and so on. So it's not something that you can necessarily win on. Again, some of these things are like really political problems that we should be mobilizing the community to challenge at the federal level, like in terms of changing the Bureau of Prisons administrative policies and things like that. Unfortunately, the courts haven't been super helpful with challenging a lot of this stuff.
So Shelley and I were told some time back that the BOP knows within 5 days where they're going to transfer the inmate to. So our question is, now Alex has been in the shoe another 60 days.
It's 100 total.
What's that?
100 total. Yeah, I think.
Oh, 100.
Oh, sorry.
Another 100 days or something. So my question is, as parents of an inmate, now the other thing we're being told is the holdup is in Texas with the U.S. Marshals, and I know that lots of times the answers are just answers to police people. You know, there's really no there's no merit to them all at all. So is there anything that we can do as parents to push along the process?
You're saying that the process for him to be removed from the secure housing unit?
Right. To be because they're telling them that
From the prison.
because they're telling you pending a transfer, but you know that's totally ridiculous. You know, I mean, the place that they're going to transfer him to has to have a bed.
Right. I'm not sure I understand the question. So
Yeah.
You're asking, like what do they tell him when they were trying to justify transferring him there?
Well, first they said they're trying to get him a transfer, and then they said, then a few weeks later they said, well, he was told that we're trying to put you in a CMU, and he's like, why? And they said, oh, he's like, do I have any more charges? And they're like, no. So they're telling him all this different stuff, so we don't know what's going on.
Yeah.
Like, we don't even know. I mean, of course we want him out of there because of the abuse, and we've been trying, but so yeah, I don't, he's not really given any
He's not given any definite answer.
I think it's similar to what happened to Abdurrahman Oda, which was that he was actually, he completed his sentence and he was going to be transferred to a halfway house. And so they placed him in solitary, you know, because of COVID, you know, precautions. That's a pretext. They have to isolate him before they release him or transfer him. And then they just simply extended it a month without any explanation. They made up some reason just to prolong his solitary. And so they're not about to transfer Alex or Oda in his case back to general and then bring him back to solitary. So they just keep them there until they decide they want to move them. But I mean, this is even without any pretext of transferring. I mean, I don't even know how many years I forgot what the number was, but my dad was kept in the SHU in solitary for years. I think it was 42 months or something.
Wow.
So they can do that. And that was all pre-trial. I mean, that was just he was the only pre-trial non-convicted prisoner along with his co-defendant in that prison. So I know they do this. They don't necessarily have to use the excuse that they're going to transfer him but I'm not sure how to challenge that. Maybe.
Who makes the whose final decision is it to transfer?
It's the BOP. Sorry. That happened to me when I was.
Is that you, Sabri?
Yeah.
Assalamu alaikum.
Alaikum assalam. It happened to me once, the same thing, like under investigation for about 8 months in the SHU and, pending transfer. So it took like 6-7 months for the, investigation. And I was found not guilty anyways, but they still transferred me. So it took another 2 or 3 months. And this is pre-COVID, like a long time ago. So it can happen. And there is, unfortunately, they're not as coordinated. They should, I don't know if it's gotten better or worse, but they do sometimes. The bed space is an issue because they're, coordinating with like thousands of different prisoners being transferred all over the country. So, and sometimes they'll say it's a security issue because technically you're not really supposed to know when you're going to transfer because it's a threat. You might plan an escape or something like that. A lot of us got a heads up, but you're not supposed to, like, he shouldn't say it over the phone, or he shouldn't say, he should just keep it until he actually gets transferred, because that can also delay the transfer. But sometimes it's calling in as parents or concerned loved ones, like, that sometimes put a little bit of pressure on them to like try to, see what's going on at least.
So what you're saying is call the BOP where he's incarcerated.
Yeah, call if he has like a counselor or a unit manager, and see. Have you talked to them or?
The counselor is worthless.
Okay.
Yeah. Everybody there is no help, but.
Which institution is it?
FCI Hazleton, West Virginia.
Oh, yeah, that's not a good place, probably.
No, it's not.
Did they say where he's getting transferred to, or does he know at all?
He's just getting all this information. Now he's told he's under SIS investigation. He's like, for what? He didn't do anything. And they won't even tell him, they're playing this game. So he doesn't know what's going on. So there he sits waiting for whatever.
Yeah. But we found out that SIS investigation can go 2 ways.
Yeah.
Either inmate or staff.
Yeah, it could go for staff too. So.
Right. And we submitted quite a few papers to different departments within the BOP, Department of Justice, Internal Affairs, and et cetera, et cetera. Because of the COVID, things are probably progressing really slow. And so maybe they're just catching up just now.
Yeah.
Did he have like what do you call it, an infraction before getting put into the SHU?
No.
It was another bogus charge at first. 30 days. They took away commissary, all that, and then when he was supposed to get put back into his unit, they said he was not going back. So he's been there over 100 days with no reason. Just they keep telling him all these different things.
Yeah, no Quran.
Kathy,
sorry, go ahead.
No, my bad. Kathy said in the comments that they do tend to keep people in solitary while they're seeking transfer. And
Yeah,
also,
if he got a shot, like an infraction, and he's in the shoe, and he's gonna get transferred, he's not gonna come out of the shoe like until he gets transferred. That's like very, very, very rarely that anybody, if they're in the shoe already and getting pending transfer, that they're gonna come out. The only thing is like you can try to put pressure on, because they're not supposed to be technically kept, I think, if there's no infractions beyond a certain time. But they're going to use the excuse of COVID probably, that, it's hard to get that space.
So Ashley's asking you, Sabri, actually how you challenged it, so being put in the shoe, and then also if you have any experiences with administrative remedies.
Yeah, I filed. It was because the place I was in was like actually a nice place, so I didn't really want to get transferred, so I didn't really try to make too much, headwind. But it's a long story. But so yeah, I had people calling in and stuff like that. I didn't really. I challenged when I was in the CMU, and I filed the whole BP8, BP9 to the BOP, and then the ACLU picked up my case, and I finally got out of the CMU. So that was like a challenge. In the shoe, it's difficult sometimes. He can. I don't know the case or the scenario. Like if he had an infraction originally, which he said he got 30 days commissary taken away and got put in the shoe for it. What was the chart? What was the infraction? Do you know?
He didn't do anything. They put him down for refusing the urine test, but there was a whole story behind that, but he didn't do anything. It was.
No, I mean, he had to, they have to have something to put him in there for. So if he refused to do a urine test, that can be,
okay, so they put down he refused the urine.
But it's usually not something that you get transferred over. I think because they saw he's a Muslim and he has an Islamic case, that they're going to try to throw something to try to, use the, get him into like, I don't know, CMU or something like that. But,
yeah.
Inshallah, Allah make it easy for him and gets out fast. I know it's a little frustrating, probably more for the people on the outside, but I just read like a lot of books and did lots of push-ups, and it wasn't too bad. It was like, I think of it like this: it's like room service. They bring you everything, they bring you food, they bring you clothing, they change your sheets. So
So I have another question for you, Sabri. What did you see with other prisoners, what their experiences was with the administrative remedies? Did you see anyone have success when filing the BPs within the prison?
Sometimes it's rare, but sometimes they do, like especially ones that know the law, and they go, and when it gets to like the warden's desk and he sees it's going to go beyond, to the regional or to the central, they start getting a little bit more concerned and seeing how they can like solve the problem before it goes, too far. So if they have like a legitimate argument and they have support and they have like legal basis for their arguments, they can, make some progress, and they'll sometimes try to squash it before it goes, to like the higher ups, because it gives them, a headache basically. But sometimes, people don't know how to write it correctly, or they let the time pass, or they do stuff that'll get it rejected, and that'll just delay their progress, or they might lose their shot, because they make it very specific, like it's time bound, to try to follow through the whole process. They did it on purpose because they know a lot of people aren't familiar with it and they're going to lose their chances. So, sorry for interjecting, but I just
thank you so much.
I just want to
that was great.
Yeah, that was perfect. Thank you. Shelly, I'll message you. I think do some more calls, because like somebody said, that's pretty much, I think, one of the most helpful things is just putting some pressure, and seeing where that goes. Thank you so much, Amith. This was super helpful, because I always feel very helpless, I think, like when I get messages or letters just talking about really awful things that are happening to the prisoners. And so I feel like now I have something to consider and see if, like, how I can use this to help them, seek certain remedies. So thank you so much. I look forward to the written version, because I don't know how good of notes I took. But yeah, thank you. Does anyone have any more questions? Or
I just got one quick question, and that is there any limitation for time in the shoe?
I don't know. Sabri, do you know that?
A lot of times the courts defer it to the security of the BOP, so they have like unfortunately a lot of leeway as long as they're going to use the argument like security of the institution or security of the inmate. They might use the argument that they fear, you know, retaliation, or they fear, you know, they fear either one of those two, a threat to the institution or a threat to the inmate themselves. And then the courts usually defer to the judgment of the BOP, unfortunately. So I don't think there's like, I know people are challenging that, and the laws are people are trying to change the laws, but as of I haven't kept up, so I don't know if anything changed. But when I was there, they had a lot of leeway to like keep you as long as they wanted, as long as they saw. Sometimes when pressure starts getting on them, then they just want to get the person out of there. You know, when like letters are coming in or lawsuits are threatened, you know, they just want to like get the person out, because, you know, if it passes a certain time and the lawsuit actually is initiated, then they have to keep the person, and they don't want that. So
Thank you.
you're welcome.
Thank you. It's been an excellent webinar. Thank you.
Sorry,
Yeah,
thank
I gotta see the recording.
you, Ellie. It's always great seeing you both. Kathy says in the comments, there is some case law dealing with extended solitary, but it's not really clear regarding the length, probably a year or more, possibly less, unless there's good justification for it. And she says, even though the UN has said 15 days or more is torture.
Yeah.
Any other questions?
All right.
Or comments? Okay. So I think I'll let you have last words, Amith.
I don't have anything else. Again, as long as you guys have my contact information, I'm always around, so you can just shoot me an email, and yeah.
Okay, that's great. Yeah, thank you so much, everyone, for attending.
Thank you.
Thank you.
Wonderful seeing you all. You know, inshallah, we'll have more virtual gatherings and get-togethers. This won't be the last time, even though this is, I guess you can say now, end to our family weekend conference. Yeah, thank you guys. Thank you.
Thank you.
Thank you.
so
Bye,
much, Netta.
everyone.
Thank you.
Bye, everyone.
Thank you, everybody. Bye.
Bye.
Good night.